If you haven't got a will, your parents are going to inherit all of your property, even if you don't want them to.
You have 6 months to issue a claim.
Given the backlogs with the justice system right now, it can take a couple of years.
Yeah.
And we see fraud on the rise in property matters.
One of those things that is stressful and tiring and time consuming. So if you're not doing that, it can end quite ugly.
We really hope you're going to enjoy today's episode of Is That Legal? But before we get into today's topics, please make sure you hit subscribe or follow and be sure to turn on the notification bell so you don't miss any future episodes. It's free, it's a massive help to the channel. Now let's get on with the show. Welcome to the second episode of Britton and Times podcast, Is That Legal? I'm Paul Britton, a solicitor at Britton and Times Solicitors. I'm based in London's Mayfair. I've been a solicitor for the best part of 10 years now, working on a variety of cases, some are quite high profile and well reported in the tabloids. On this episode, we are going to deal with a topical subject at the moment as cases are on the rise for probate disputes, inheritance claims, and future planning. I'm joined by two great guests from Britton and Times Solicitors. Let me introduce this. First of all, I have...
Hello, my name's Patrick Rusk. I am a solicitor in our Hove office. I've worked in law firms for 4 years, but prior to that, I was a legal translator, translating legal documents from German into English.
Great, welcome Patrick. And joined also by...
My name is Darian Wielink. I'm a private client solicitor. I've been in the legal profession for about 3 years now. Before which I was working towards my Bachelor of Arts in History and then my Bachelor of Law with a Juris Doctor.
Excellent. Sounds like an interesting academic history and working with law. How's your day been today, Darian?
A bit hectic.
Yeah?
Getting lots of wills done, working on estate accounts, which is, a long document for what we'll be discussing later on today.
Okay.
But, yeah.
And is it a busy time for wills and probate cases?
Yeah, it's never, a dull moment.
No? In the summer? So
Yeah.
so everyone's come back from school?
Yeah, exactly.
Yeah. And Patrick, how are you getting on?
Good, but busy. I've had a varied day. As we know, the Renters' Rights Bill's coming in, some advising clients on that, also dealing with private wealth matters today. So it's been varied and quite busy, but enjoyable.
Yeah, and private wealth matters, I guess that segues quite nicely into inheritance, because if you've accumulated some wealth, then you're going to want to leave it to people. So let's start with that, really. Some people might be thinking, what is inheritance? So Darian, do you want to start us there?
Yeah, so inheritance is the act of giving away your assets. So your property, your money, your cars, personal possessions, anything that you want to give. And the people that you give to are referred to as beneficiaries.
But yeah, beneficiaries can be a technical term, but essentially the people that are getting the stuff.
Yeah, exactly.
And when people talk about getting a grant of probate, Patrick, what's that process? What does that mean?
So that means a lot of the times you need a grant of probate to sell a house, for example, and that is the bit of paper that gives you the permission to sell that house. It shows the banks, estate agents, that you have the permission to act on the deceased person's behalf when they're no longer with us.
I guess an important document and something that's quite necessary. Otherwise, what would happen if you didn't have that process in place? Everyone would be going around selling someone's house.
Selling someone's house with no permission to do so.
Yeah.
And we see fraud on the rise in property matters, so it's really important that we get that right.
Are there any conditions that require the grant of probate?
Yeah, typically with bank accounts, for instance, a lot of financial institutions will have their own set rules. Typically, if a bank account has around £20,000 to £25,000, they won't necessarily need to see the grant of probate. They'll likely ask to see the will. For a property matter, as Patrick was saying, the land registry will want to see the grant of probate. Your conveyancers, the solicitors who are help you with the property will want to see it. They just want to make sure that they are dealing with the correct people.
So is there like a threshold where you need to go and get a grant of probate, or can you just make do without one as long as the banks cooperate with you?
Yeah, it really depends on the assets, the things that you have in your estate. Where jointly held assets, such as bank accounts that you hold with your spouse or your cohabiting partner, or where you're joint owners on a property, you won't need a grant of probate. It's gone through what's called, this is going to be like a legalese term, but doctrine of survivorship.
Okay.
It means the person who survives the other will just automatically inherit.
So if you're a couple and you're married and one passes away, the other partner automatically inherits.
Essentially, if you hold all of your assets together.
Okay.
So if you had your own sole bank accounts, one of which was, say, Patrick and I had a bank account together, whoever died first would get that. If I had a sole bank account, Patrick would likely have to get the grant of probate to get any money out of it.
So when it comes to drafting a will in the first place, for anyone listening that hasn't got a will, let's say, or wants to update their will, what's the first step for them?
Well, the first step, I think, is talking to a lawyer, because Darian and I have both seen cases where people have done it themselves, the best intentions in the world, and unfortunately they don't get it quite right, and it causes problems, confusion down the line. So it's really important to talk to a lawyer, because they can help you understand what it is you're actually trying to achieve in writing a will, who you want to benefit, who you want to inherit your assets. If you do it yourself, you can create confusion, and then your executors are having to deal with legal problems further down the line that could have been avoided.
When you say people that draft their own will don't always get it quite right, what sort of examples have you seen where someone has? I mean, are we talking about writing it manuscript or typing it on their computer? What sort of examples have you seen?
Both. I mean, I've seen it where a word, because of the handwriting, you actually can't read what the word says. We've seen it where they want to leave money for someone when they get better, but that, legally speaking, we don't know when they're better. So it creates that confusion. We don't really know who's going to get the money and when they're going to get it.
So it might say, I want Patrick to inherit when he gets better.
And what does that mean legally?
Yeah.
You're going to have to go to court to have the court decide that. And
Financially better, but
mentally
mentally better,
better.
physically better.
It's very ambiguous.
Yeah.
Another issue that we see is that they list specific assets.
Yeah.
So a will can only give that person who's dealing with the will or dealing with the administration of the estate power over those assets. So anything beyond that would be what's called a partial intestacy, and it goes to completely different rules.
So does this mean if I had 5 properties and I put 4 in my will and leave the 5th one out, the 5th one can't be dealt with under the will, so it falls under the intestacy rules?
It could be if you forget to leave out what's called a residuary estate.
Okay.
So that's where there's a concise phrasing for pretty much everything else. So the way that I describe it to people is when you make a will, if you're gifting certain things, you're taking them out of a pot. And if you don't reference that pot at the end of your will, then everything else that's not mentioned in your will.
So it's basically whatever's left
Yep.
will be distributed like this.
Yeah, exactly.
To the named beneficiaries, for example. Yeah. Okay. And I mean, we've mentioned intestacy rules. Now, for a lot of people who are listening, they're going to be, I don't know what the intestacy rules are. And I remember before I read law, I had no idea. So who wants to delve into explaining as simply as possible what do we mean by, when do they become applicable, and what do we mean by the intestacy rules?
I can take that. So intestacy is where, the simple answer is where there's no will. And we have to remember that the rules are written by Victorians. They were written almost 100 years ago. So it's going to follow family lines down a ranking. So first of all, it's going to go to your spouse, your wife, your husband, civil partner. Then it's going to go to your children. If you have no children, then it goes to your brothers and sisters or your parents. And eventually we go all the way down the ranks until someone inherits. The problem is you don't get a choice in that. So if you have a family dynamic where, I don't know, you haven't got a will, you're not married, you haven't got any children, you're not on the best terms with your parents. If you haven't got a will, your parents are going to inherit all of your property, even if you don't want them to.
Under the intestacy rules?
Under the intestacy rules.
So you don't want your parents to inherit, you die without a will, and it could pass up the chain.
Up the chain. Against your wishes.
I think it's even more of one of those matters that you want to think about, especially in the modern era. A lot of people are cohabiting. Me personally, I cohabit with my partner. We're not married, and so my spouse wouldn't inherit anything if I died. My partner wouldn't inherit anything, and So because of that modern shift, people are living together before they get married. They're financially dependent on one another. And so if you don't have a will, and it goes to the rules of intestacy, you're not ensuring that your assets, your estate, goes to who you want it to.
Does your partner have any claim, any possibility of some sort of redress or able to claim on your estate after you're gone?
She does.
Yeah.
It would be quite a difficult course to go down. There's a provision in legislation called or what's colloquially referred to as the 1975 Act. And it provides for financial dependents and family members to make a claim. But the restriction is you have to be living with each other for 2 years prior and have to be living together as a couple. And so you have to prove not only that you had been living together for 2 years prior to the...
How would you prove something like that?
That would be based on council tax statements or tenancy agreements, utility companies, anything like that. And I guess the second part is proving that you were living together as a couple. How do you prove that it would just be by witness statements?
Facebook photos.
Facebook photos.
Instagram photos.
Yeah, if you have that out there.
Yeah.
Private text messages.
Private text messages, yeah.
But this would be a pressure put on your partner because in this scenario, you wouldn't be here anymore.
Exactly.
But can be avoided simply by drafting a will.
Yep.
Have you done your will?
I'm working on my will right now.
Patrick, have you done your will?
I've drafted it. I need to take legal advice on it myself.
But you're almost there.
We're almost there.
Okay. So we have got a situation where if you pass away without a will, it's the intestacy rules, and it could go to the people that, one, might not need it, and two, you don't want to have it, and can cut out your spouse. So really the importance of having a will is quite high. In terms of the 75 Act claim, what would someone be looking at in terms of if they were in that situation, the situation we've just described, will-less, not married, cohabiting, let's say they've been, what would their first steps be?
It would be talking to a lawyer because these are, frankly, very complex claims to bring. We need to look at what sort of evidence you can actually provide to the court. Because we always have to remember, a judge doesn't know you. A judge doesn't know your circumstances. So we're going to have to get all the evidence we can to show that you're a cohabiting couple or whatever the relationship might be, and determine to what extent you are financially dependent on that person, because that's what a judge is going to care about. We also have to have in mind these are really emotional cases because you've just lost a loved one. And the last thing you want to be doing is going in front of a judge to spell out your relationship and justify getting a financial settlement out of their estate.
When you're supposed to be grieving.
When you're supposed to be grieving.
How long do these sort of cases take, let's say, to get to court?
Given the backlogs with the justice system right now, it can take a couple of years.
Okay.
The claim form, which is the first step in getting it in front of a judge, a solicitor can knock that out in a matter of, a couple of weeks after taking instructions.
So that can be quite quick.
That can be really quick. But getting it listed in front of a judge can take a long time, unfortunately.
And are there timelines or time limits, I should say, to bring in that sort of claim? Can you wait 3 years, 6 years, 10 years later, 20 years later? How quickly do you have to act to bring a claim under the 75 Act?
Once you've got background of probate we mentioned earlier, once one of the executors has that, if you're challenging a will or if it's an intestacy, it's a slightly different document. Basically, 6 months after you've got the court's permission to administer the estate. It's a really tight deadline.
Okay. You've got to act quite quickly and speak to someone if you're going to bring it. When you talk about a contested will, how can someone contest a will? So let's say a testator or testatrix have drafted their will, they've executed it correctly, they now pass away, and you've got the grant of probate, but someone comes out of the woodwork and says, I want to contest this will, maybe they weren't provided for. What sort of grounds would they have to say, I don't like this will, I want to challenge it?
I think the first thing to point out is just because you don't like it isn't a legal ground to challenge the will.
Okay.
There are, the main ones are the person who's passed away didn't have the mental capacity to make the will, i.e. They weren't mentally able to do it, they didn't understand what they were writing. Or the other main avenue we see is undue influence, where they understand the contents of the will, but someone has effectively forced them to sign it against their will. It doesn't have to be physical. It can be sort of oppression. It could be mental coercion. But that the key word is coercion. They've been coerced into signing something that doesn't actually reflect their wishes.
And then is there, I have heard like improper execution. So Darian, what would be if someone said, oh, it's not been executed properly, what would they be going on about?
Yeah. So essentially, when you execute a will, when you sign a will, there are a couple of formalities that you have to ensure are done to make sure that it is legally valid. One of which is the signature. It has to be the testator, the person who's making the will, that they have to sign the document. And it has to be witnessed by 2 independent people. And by independent, I mean they aren't mentioned in the will, or they aren't really closely connected with the testator.
So would a blood relative be a problem witnessing the will?
It could be a problem, especially if there are any direct links to them and the will. Essentially, what happens if a witness is mentioned in the will, it invalidates their gift.
Okay.
And so it won't invalidate the whole will, but that witness won't receive the benefit of whatever is left to them in the will.
And 2 witnesses, ideal witnesses as independent as possible.
Yep.
So accountant.
Yep. Or
lawyer.
Solicitor. Yep.
Okay. Someone. And what is the purpose of having those 2 witnesses?
It's to ensure and validate should the will ever be contested for undue influence or oppression, or that it was actually signed by the testator.
And we've mentioned signature. I mean, the signature of the person wanted to draft the will. We always say testator or testatrix,
Yes.
the masculine and feminine of the person drafting the will. Are there situations where a signature can be just a blatant fraud, a forgery?
It could happen, and it does happen.
Yeah.
I think you get to 2 extremes. Technically, it doesn't have to be a signature. It has to be marked by the testator or testatrix. So, I could sit down and sign my will with a happy face. And as long as I have 2 witnesses who can attest that I did, in fact, mark my will
With a happy face.
with a happy face, that would likely be held up.
Be valid.
It would be valid. But it's also about identifying the forgery or identifying the signature. Because if, it comes down to the line that the 2 witnesses had passed away, say you had a will from the 1960s, and the testator, has to identify their signature, you'd want it to be recognizable. And as little to,
So if it was Paul Britton, we would want it to at least look like
Exactly.
it was Paul Britton.
Yeah.
Okay. Any other formalities about execution?
Not necessarily for formalities, but things that you should do. You want to make sure that your witnesses can be identified should your will ever be contested.
How do you ensure that?
By putting their full names, addresses, occupations, and then also making clear which is the date of the will. Date the will to make sure that if you do have any previous wills, that this one revokes those wills.
And it might be a silly question, but some might be. Is there any particular order people have to sign?
The formality is you have to this will has to be signed in the presence of 2 of the witnesses. Now it's always suggested that the testator sign first and then the witnesses.
Because then you've actually witnessed the signature.
Exactly.
Okay. It's a silly question,
No, but it's a good one.
It's very valid.
Yeah.
Patrick, have you ever had any cases where there has been invalid execution or a forgery?
I've had an interesting one where it was an English will dealing with French property.
Right.
And we were arguing with French lawyers about whether it was an English will or a French will. And we won that one because it was a will according to 2 witnesses. It's different to French law. And we've successfully argued that it was actually an English will because it had met the requirements that Darian's spoken about with the 2 witnesses.
So we're talking about cases or challenging execution. Thinking about the administering the estate, who's tasked with someone's passed away. Now everything rests on the shoulders of who?
So that would be the personal representative, as we like to call them.
Okay.
So it takes forms in 2 different terms. Either you can be the executor, so you're executing the will in accordance with the law, or the administrator, who went back to that term, the rules of intestacy. If there's no will, it would be the administrator. Now, because you, as a personal representative, you do owe what's called a duty to administer the will or the estate in accordance with law. And that duty is owed to the estate and to the beneficiaries. So if you're not doing that, it can end quite ugly. For
So
the
what
executor.
sort of things like fall into not, if you're naughty and you're not doing your job properly, because it falls under the law.
Yeah.
And sadly, not everybody knows the law because most people watching this probably haven't been to law school.
Yeah.
So if you were tasked with administering that estate, with dealing with what the will tells you to do, what sort of things could you fall foul of?
Well, mixing funds. So I have to act when a professional and my personal funds have to stay separate. So the estate funds can't mix in a personal bank account.
So I can't transfer all the bank accounts of the deceased into my account just because I'm named as executor.
No.
So what should I do?
What I would do is open up a separate account.
Okay.
Or come to talk to a solicitor who will typically, if you instruct them, offer to use their client account or their bank account as the estate account. It makes sure that they are kept completely separate. And that's something that, we as solicitors offer as part of our services.
What other things could they fall in trouble of?
They have to act with what we call the utmost good faith. So if they cause any loss to the estate, if they bet it on a horse thinking it's going to create a profit, but then they lose the money, that is going to land them in trouble.
Who's liable for that if they do that?
They are.
They are. Okay.
They are. What might happen is if it goes to court for any reason, as long as they've acted reasonably, the judge might let them off.
Okay.
But if they're acting unreasonably, like betting on a horse, going to Vegas, the judge is not going to be so kind on that.
And what would the outcomes be?
They have to pay them back. They have to pay back every penny that they take out of the estate and waste.
And if you've got someone who's not doing their job at all and they're just sitting on it all, how long can they sit on it for?
There's not a real defined time period or time limit. The fiduciary duty is to act quickly and promptly and wound up the estate and distribute it in a timely manner. If that was the case, if they were sitting on it for a year or two, I would definitely recommend seeking legal advice as to what options you have, such as making a court application to say, relinquish your duties and renounce.
But who's going to have those options? So let's say there's one. Can you have one executor? So
Well,
they're not doing it. So who's going to challenge them?
essentially, it would come down to the rules of intestacy.
Yeah.
And who actually, it comes down to different kind of rules, but there's a different priority system if there's a will. And it goes to the residuary beneficiaries first.
Right.
So that's the people who will inherit everything else other than what's been taken out of
If
the
you're
pot.
named as getting the proceeds of the estate, you're going to inherit. You can challenge the executor
Yeah.
if they're not administering the estate and you're not getting your money.
Exactly, because that's one of the rights of a beneficiary.
Okay.
In the inheritance, beneficiaries have very limited rights. Now, the rights, include the right to have the will administered in accordance with the law. It includes the oversight of the estate accounts, which I mentioned earlier.
So beneficiaries can see the accounts
Yep.
of the estate. They have a right to that.
Yeah, but they don't have a necessarily right to all of the information
No.
and decision making that goes into it. People will often ask, for updates, but they aren't necessarily entitled to that information. They're entitled to see what goes in and out of the estate at the end, period. So,
Nice.
Yeah.
Okay. Anything you want to add, Patrick?
Just to say that a lot of clients feel left in the dark by executors because, as Darren was just saying, they don't have to put all their cards on the table. They don't have to justify every decision. But if you feel that an executor is acting unreasonably, talk to a lawyer and either they'll agree to release the information or we'll sue them for it.
Okay. Well, we can do that.
We can do that.
Well, if there's two executors and they're not agreeing, or more, 3, 4, 5, what's the process then?
it does happen.
Yeah.
I've been on working on a matter previously where it wasn't a will, but it was administration, and there was no will.
Okay.
And it went down to the siblings, and the siblings couldn't agree on what to do. And it becomes quite frustrating, especially as executors and administrators have to act unanimously. They can't act individually. And so when that's the case, it can get to a point of going to what we call mediation. So you have a third party who's neutral.
I mean, that's great, because I was going to ask you next, like mediation versus court. So go on, mediation.
Yeah. So mediation is what we call an alternative dispute resolution. That's a big fancy word for having a third party come in and basically go between the parties to discuss where their points are and what their strong points are and what their weak points are and where they can meet in the middle. And that's the end goal. As lawyers, as much as, pop culture and television shows like to portray us going to court, our end goal is never to end up in court. It's always to make sure that we settle it in whatever means possible, because that's in the client's best interest. And mediation is one of those routes. I've been in mediation on previous matters, and it works surprisingly well. And so that's what, if two executors couldn't, meet minds, take them to mediation, get to see their differences and get to see their points of view and work it out that way.
So mediation can work.
It can, yeah, and it often does. Court can be very, very expensive, and it's one of those things that is stressful and tiring and time-consuming. And mediation, it's it'll take an afternoon or a day or 2 days, but it's a lot less expensive and it's a lot less stressful.
One of the things I always say to clients is, as Patrick was saying, get the claim issued. So your timeline starts.
Yep.
You're not going to be in court for 2 years, and you've got 2 years now to settle it.
Yeah.
But at least you've started the claim. You've got the ball rolling. You've got a nice, helpful court timetable where the parties have to do things by. Yeah. And in the background, I always say you can mediate. You can settle at any time.
That's exactly the thing with the 1975 Act that Patrick mentioned. You have 6 months from the date that grant of probate has been issued to issue a claim.
So get your claim issued.
And then you've got
2 years to settle.
Yeah, and then you can, at least it's in the system.
Yeah.
You have, another 4 months to serve it on the defendant. But beyond that, you can take your time to work out the issues and the underlying things that you want.
And I would say I do very much enjoy arguing in front of a judge.
Yeah.
So not all lawyers want to end up in court. I do personally, but these sorts of disputes do lend themselves quite well to mediation because it's usually down to brass tacks. It's going to be, they have a figure in mind, you have a figure in mind. You can almost always meet in the middle and find a solution that people can live with.
I mean, talking of solutions, one of the cases that Britton and Time Solicitors is most famous for and recognised for is that we're the leading authority on undue influence in the Rhea case. And I remember I met Rita, probably 5 years ago now, when I took over her case, and I've been in the court with her 3 times, the High Court, the Court of Appeal and the Supreme Court, one in the Appeal and one in the Supreme Court, and now it's a binding authority. Patrick, really, because you're a litigator at the firm, and I know now you're working with Rhea.
I am.
On the enforcement side, but tell us a bit about the Rhea case.
So Rita's case is interesting in that when it started, it was a fairly bog standard undue influence case. So this is
brought by her 3 brothers.
For her 3 brothers against their mum's will. So what happened was Rita had given up her career to look after her mum in her later years. As a reflection of that, bearing in mind Rita's mum had written her will many, many years prior when Rita and her brothers were children. So in light of Rita's help, she updated her will to give her slightly more of the inheritance. Her brothers saw that as Rita influencing their mum, brought a claim, and managed to convince a judge that Rita had unduly influenced their mum's will. This is an interesting case in that the judge, summing up all the evidence, added up 2 and 2 and still came to 7. So unfortunately, judges don't get it right every time. So as you said, we had to go to the Court of Appeal. We won.
On every point.
And as I say now, Rita's case is the gold standard. It sets the bar for what you need to do to bring an undue influence case.
Before we continue this episode, a word from our sponsor. This episode of Is That Legal is sponsored by Oliver Lorenz Studio, your on-demand design team for B2B service providers. They're your dedicated design partner, delivering consistent, high-quality creative without the overhead of hiring in-house. Think bold branding, polished presentations, and visual content that actually moves the needle. Check them out at oliverlorenzstudio.com. Design support just when you need it. And one of the facets in the Rhea and Rhea case is that the brothers were alleging that because the valid will, I'll call it the valid will because it's the one, so the last will and testament, it was unduly influenced in some way. How can you describe, how does the court approach something like that?
So the starting point, and this is what they confirmed in our case with Rita, the undue influence of a will is inherently unlikely. So we start from that position. Whenever you bring a claim in the civil courts in England, so anything, not crimes, basically anything other than the criminal courts, you have to prove something to basically more than 50% likely that your version of events is correct. So we already start that it's unlikely that they've unduly influenced the will. So let's say they use the analogy in Rita's case that if you see a lion, or someone tells you they've seen a lion in the park.
In England.
In London, it probably wasn't a lion, right? It's probably a big dog and they've lost their glasses. But then we start talking about the evidence that sort of surrounds everything. So if you then take into account that, you're in St. James's Park in London and there's a zoo in St. James's Park, and you go to the zoo and the lion enclosure's doors open and there's no lion inside. All of a sudden, because of all that extra evidence, maybe it was a lion. Maybe you really did see a lion.
It was that lion that escaped.
And so in an undue influence case, if you've got all the other evidence to say, for example, if you've got a carer who's excluding the testator, the deceased family, lying to them saying, oh, your children never come see you.
Poisoning their minds.
Well, actually, on the other hand, saying to the children, no, you can't come today, your mum's not feeling well. You start ordering all that evidence, and then we arrive at the conclusion, maybe they did unduly influence the will. If the carer is the one receiving all the inheritance, excluding all the children, we had that evidence, and then that's what Rita's case taught us.
So you've got to scratch a bit deeper.
Got to really dig into. You got to be a private investigator and figure these things out.
And that's actually the value of lawyers, because you've just done it very articulately, almost like it's second nature to you, and it probably is because of the volume of cases that you do, and for me as well. And so it's easy for us to do that. And I think often what I find with clients they don't appreciate is that they get one go at this. You get one good go in the county court, in the high court, wherever your case starts, depending on its value and its complexity. You get one go. People are like, well, then I'll have an appeal. Appeals are very limited. And what I find people mistaken a lot about appeals is that they're going to have a retrial in the Court of Appeal. No. If you are successful on appeal, the appeal court will order a retrial, but it goes back to the lower court for the retrial, the county court or the high court. And well, that opens up yet another avenue for appeal, which is actually, what happened in Rita's case. The brothers won the first time, she won the first time round, went to the Court of Appeal. The Court of Appeal said the brothers had an unfair trial, went back to the high court for a retrial. She was unsuccessful. She appealed, she was successful. They appealed in the Supreme Court, they were unsuccessful. Overall, she won.
Back and forth.
And each time, sadly, and as the point that you made, Darian, which was excellent about the value of the estate, the more time, lawyers sell time, the more time a lawyer spends on a file, the bigger that legal bill is going to be. So being in court 5 times, it's 5 times what it should have been in her case. But someone's got to pay that, which is why now we turn to the brothers to pay her legal bill, because that's what's right.
Pay they will.
Right, we've got some questions from people who have written in. Let's have a look at what these are. So I've got this one. My mother passed away last year, and she made a will naming my older brother and me as beneficiaries. My brother is the executor. But ever since mum's death, my brother has been delaying applying for probate, and he hasn't shared any information about the estate assets and liabilities. She says, We know there is a house, bank account, some investments. I am worried that things are being mishandled or hidden. I've asked several times, but he says it's complicated and I needn't worry. Is there anything I can do? So, I mean, Patrick, that probably comes to you as more of a litigator. Her brother's the executor of this estate. She knows there's assets. She's got limited access to any documents, bank statements, land registry. How can a lawyer help? You know, we did say about being an investigator. What can we do?
So you can hire actual investigators. You know, people think private investigators are something that exists in film noir, but you know they are real, and you can hire them. So if you need to know, what assets there are, you can hire someone to look into them. We can do an estate search, which is we can look at online records to find out what exists. But as Darian was saying, while an estate is being administered, your power to look at the accounts, to ask questions is somewhat limited. But this is subject to the caveat that, the court will step in if they feel that the executor is not doing their job properly. So what I always tell clients, if you can't bash your heads together and agree, the judge will bash your heads together and decide for you. So agree or be judged.
Yeah. Okay. Well, but the salient point for her is that go and see a lawyer.
Go see a lawyer.
And the lawyer might direct private investigators, but they will be the ones that do some investigation works to find out what is going on. What if lawyers find out there is something untoward, that something has been sold and the money's gone awry?
If that's the case, then it would be coming after her brother to repay what was lost. Now, even in that, it can be expensive, but it can be worth it. In some cases, if he sold the property and gambled it on, went to Las Vegas and gambled $100,000 away, that would probably be worth the while.
And she could ask the court to make an order to remove him as executor.
She could, yeah. Where he's been, acting
naughty,
not
hands in the till.
He could be removed by the court. Because he's not acting within his duty.
Could she, as a beneficiary, apply to administer the estate going forward?
She could, but it happens more likely than not that it would be an independent administrator. So the court may apply for someone a solicitor or a neutral third party, an accountant, to take over those proceedings. And that's typically what you might see happen, especially if beneficiaries and executors can't see eye to eye.
No.
They don't want to risk, the courts doesn't want to risk further, litigation or contention. They want to nip it in the bud and say, this is silly, let's get this done. Especially if that process has been going on for, a number of years.
Because there's a right, I mean, in litigation, as Patrick, there's a right to an end of litigation. So you can't just tie things up in the courts forever. And it's actually a fact that judges always have to be mindful on how long has this gone on for. When claims are very old, we refer to them as stale claims. They've been around for too long. There's got to be an end to it. Almost whether it's right or wrong, it's got to be an end, no more. Okay. Right, we've got another question. Let's have a look at this one. My father made a will a few years ago, but he was ill with early dementia. He changed his will shortly before he died, leaving out one of his children in favour of a caregiver. I suspect undue influence. The caregiver was very involved, maybe pressured him. I want to challenge the will, but I'm not sure what grounds and what evidence I would need. Also, I'm worried about the cost, time, and whether I'm too late.
This is I think it's a confusing topic for many people to wrap their heads around, because dementia, while it can symbolize the loss of mental capacity, it doesn't necessarily go towards testamentary capacity. Now, what I mean by that is, people might be losing their marbles, but it doesn't mean that they don't have an understanding of what their estate consists of and the moral obligation. Now, there are a couple of, or there's one particular case that, we as solicitors look towards, and the judge will look towards, called Banks and Goodfellow. And it sets out kind of a 4-limb test to just determine whether someone has the capacity to make a will. And two of those things matters that I hinted at were the size of their estate, so they have a good understanding of their estate. They know the moral obligations, so they know who they should be gifting it to, and those are things that will be taken into consideration, and that they're not under any psychotic episodes or poisoning of the mind.
And coming on from what Darian's saying about knowing who you ought to leave your assets to, on the topic of undue influence, as a litigator, I always think ahead to see what are they going to argue on the other side. And I'd want to know what the relationship was with the child who's been excluded. Because just because a caregiver's been left something to the exclusion of the child, there might be more to it than that. Maybe the child hasn't actually been around, been looking after, visiting, whatever it may be. And maybe the caregiver has been there, like in Rita's case, we just don't know until we've spoken with, the person who's concerned.
We've done some digging.
Get some more information and understand a bit more about, this carer, the family dynamics, what's actually been going on. And then that will give us a better understanding of whether there's been any foul play.
And people always ask me about what is the gold standard of preventing these disputes happening at the will writing stage. And should I go to a will writer?
Yep.
And I always categorically say, no, you shouldn't go to a will writer because it's a 6-week course and then you're let loose, unregulated, uninsured. How much experience have they actually had? When I have a client who is older, 60, 65, 70 plus, I will often do a letter that they can take to their GP, and it's in a sealed envelope. If I can get their GP's details, I'll send it directly to their GP, and it will ask them to ask questions of my client, things like, do they understand the value of their estate? And it's all very well someone saying, the value of my estate is £1 million. Right, great. What does that get you these days? And if they turn around and say a loaf of bread, there might be a problem there. Yeah, I mean, it's like that question that people ask politicians. You're out of touch, Minister, aren't you? No, I'm not. How much is a pint of milk? Oh, well,
£10?
I've never looked. Yeah, I've never looked. Right? Or they go ridiculous 25p. Yeah, maybe in 1980, right? Yeah. Not anymore. So it's those sort of questions. Who is the Prime Minister? When was the last general election?
We've had quite a few, so that might not be the easiest answer to.
Yeah, well, that's true. Well, I don't know. It's an even better question, isn't it? Like a revolving door. If they can name them, it shows that they've got good capacity or sees the fact. So it's really understanding the value of their estate and what that means today in pounds, shillings, and pence. And then when I'm doing the will, I would always want them to do the wills questionnaire. And if they couldn't, and I'm the solicitor meeting with them, I might take them through it. I would get them to sign it at the end, just the wills questionnaire, so that they read it. It's their instructions to me, and they've signed it. And if there was something peculiar, a little bit odd, like disinheriting someone or giving it to the carer, I would produce a separate document that we call a letter of wishes, and I'd say this needs to set out why you've done what you've done in your will, so that if there is a dispute after your death, and they say, well, why was I disinherited? Why didn't I can just whip out your letter of wishes and say, well, this is why. Yeah. And it's also very helpful for a judge, because you can't get a witness statement from someone that's passed away. No. But it's very helpful for a judge to sit there and read a letter of wishes alongside them and say, well, look, this is why your aunt did it. You've not been around for 10 years. You had that row in 1997. Did you forget that row? Well, she sets it out quite clearly here. And you stormed out of her house. You slammed the door and broke the window.
I've had one extreme case where someone actually recorded themselves at the solicitor's office. So they did a video, set up a camcorder.
Like a deposition.
Like a deposition.
CPR, yeah.
But you said you can't do a witness statement once you've passed away. But you can do a video when you were alive. Bit extreme. But the reason it came about was because one of their disgruntled children had been left out. Actually, very similar situation to what you were describing. He'd stormed out of the house after an argument. They knew that he was going to make a claim against the estate no matter what they put in the will. So what they did is they got to the solicitor's office, set up a camcorder, recorded themselves saying, I'm of sound mind, this is my will, I understand its contents, and I'm leaving out so-and-so because X, Y, Z. So when he sent that claim, we could say, well, look, here's a DVD of your mum saying, you know what, no, I don't want to include him in my will. And the claim went away.
See, and I think it's important to point out, like, these are, a letter of wishes is going to be really helpful with certain types of claim, undue influence or, validity of wills. When it comes to 1975 Act claims, it can be a different story because that's not going towards, someone's capacity. That's going towards reasonable provision or reasonable financial provision. So the court will look at a letter of wishes and say, okay, that's fine that you didn't have a relationship. But the court also might say, that doesn't actually take into account whether or not you should have left them reasonable money in your will. And it's actually can hinder that argument from the estate.
I mean, this actually comes up quite a lot.
Yeah.
I mean, for me, when I'm talking to clients, same-sex couples in later years, two men in their 70s, been together for a long time, 20, 30 years, 40 years. Gay marriage wasn't a thing, so they never got married. Too old now to be bothered, didn't do a will, and one passes away. And then we're under the intestacy rules. Okay, they're not a blood relative. They never married. Arguably, they get nothing.
It can be devastating.
Absolutely, yeah.
I mean,
you both bought a house together, but maybe only one of you bought it. In a time where you didn't want it to be publicly known that you're a couple, so one of you bought it. Yes, you both discharged the mortgage, but you did that by paying into their account rather than direct to the mortgage account. How do you prove it? You've just been living there.
Yeah.
A family member might say, you've been a freeloader.
Yeah.
And now you've got to get out.
Yeah. And they might also, going back to that undue influence and that, the question of dementia, it's, proving that is proving the person had dementia or proving that they had undue influence or proving that they didn't have a relationship.
Yeah.
It's not something that's uncommon.
No.
I've seen it before, and it's wreaks havoc on someone's, life.
Yeah, well, mental health as well. I mean, you've built a life together, although your name's not on the documents.
It can be so easily fixed. That's the message
With the
for
will.
viewers. You could do a will.
You've not done one, you've not done one.
But I've given my partner all the clues, all the little cues he needs to make a claim against me. So in the meantime, if I drop dead tomorrow, I've given him.
But you said I was going to get it, Patrick.
If I've
You're
made
going to split it between me and Darian.
I said it's 50-50, baby. We're in it together. But on a serious note, he knows we're in it 50-50, and there are claims you can make.
Yeah.
Obviously, it's far from ideal. As I say, I am getting, irony being, as a lawyer who specialises in this area, I'm still getting legal advice on the will because I want to make sure I'm doing it right and I've not missed anything.
What would you say to someone that says you just get married?
Who get married? If you're watching, Oscar.
Hint, hint.
You could. I mean, that's one solution, isn't it?
It is one solution. For us.
But under the intestacy rules, that's not going to protect it. Absolutely, is it?
No, absolutely. So with a spouse, for example, Oscar and I, we don't have children.
No.
So everything as a default would go to him. But for example, that doesn't leave any protection for my family, my parents and my siblings. So while it mostly works, I can tailor my estate, how I want my estate to be administered to leave, gifts for my sister or the dog's trust, I'm going to leave something for the guide dogs,
But there's a good reason to do that.
There is.
There's a tax efficiency, isn't it?
There is.
What is that, Darian?
So if you give 10% of your estate to a charity,
A registered charity,
you can get a relief from inheritance tax. So it brings it from over the tax threshold from 40% to 36%. And so you have to weigh up the pros and cons of, well, if I give 10% of my estate but I save 4% on tax, is that really going to benefit my beneficiaries more?
The size of your estate.
Yeah, exactly. So for some people, it might not be worth it. But I think, giving to charity in any case is a good cause. I'm not trying to, have any money go to the guide dogs. But
10%. So you're going to the guide dogs?
Mine is the guide dogs.
Okay, fine. Is there any reason for that?
We've got a beautiful little Labrador puppy called Theo, and there's a guide dogs training centre in Hove, and they train not just Labradors, but they train guide dogs for people who. My dad is an optician; he's just retired, but he works with people who've gone blind, and the guide dogs is a life-changing charity. They do amazing work for people who are inherently vulnerable.
Okay. So that's where you're going. Right. We've got another question from one of our viewers. I've just discovered that my late aunt's will may have been forged, or at least parts of it seem suspicious. Signatures, handwriting, missing pages. I believe there are earlier drafts that left me some property, but the versions filed looks very different. I don't know if there's enough proof, but I feel something wrong has happened. What should I do, and what are my chances?
I think from an administrative point, the viewer mentioned that the will was missing pages. So as part of the administrative process, you'll have to apply to the court for the grant of probate or the grant of representation with the original will. And the first thing that the court will do is look at the condition of the will. And so where there are pages missing or it's not bound, even recently I've had a will that has been what we call requisitioned by the court to understand the condition of the will. And where it looks like there's...
What was wrong with it?
It wasn't bound.
What does that mean?
So it wasn't stapled or tied together.
Just loose pages.
It was just loose pages.
And what's the risk of that if it's just loose pages?
Well, the court might say, there's pages missing. How do we know this is the full and complete will?
Well, someone could sub a page out and put a page in.
Exactly.
So it's important to bind them
very,
all together.
very important. And so what the executors will then have to do is justify why it hasn't been bound, why it's in that condition, and how long it's been in their hands for before it was being submitted. Because the court does take it very, very seriously. And where there is a potential that there's been a forgery, what you could potentially do to stop any procedure going forward is put what's called a caveat in place. Now, what that is a fancy legalese term for stopping all of the process and applying to the court to say, we're investigating the estate. We don't think this is the correct will, and the court won't, approve the grant of probate until that has been lifted.
I've got a case like that on the go at the moment. I also had a case where the solicitor, actually no one in our firm, in the firm next door, had, and he was retiring, so I got the file after his retirement. He had removed the staple in the top left-hand corner for the purposes of photocopying. Then he retired, and the files came to our firm, and I had to go and find him to explain that it had been inadvertently removed for the purposes of photo and do a witness statement so that the court would accept it.
Yeah, and it can be things such as
an affidavit. They had to do an affidavit. On promise,
It can be things such as small little creases in corners, or staple hole removed, or a little tear, because even a tear could symbolize, if done with the intention to destroy it, that it should be revoked. So there's the tiniest of things can delay.
So tearing up a will or tearing it slightly could be a demonstration that you've revoked it and you intend to destroy it.
Exactly. And so that's why you have to keep your wills in pristine condition and keep them all together. In terms of the forgery, I'm sure Patrick can discuss that in greater detail. But you have, handwriting experts who can give some indication. The con of that is that you'll have to find numerous examples of the signatures to really validate whether or not this signature is real.
Of course. With forgeries, the starting point is that the person, will in hand, they're saying, this is the last will and testament of Mrs. Bloggs. It's up to them to prove to the court that that's a valid will. But there have been scams recently. I was listening to one on, I think it was BBC Sounds. There's a Hungarian gang using signatures they found on land registry documents, which are publicly available. You pay £8 to the land registry, you get some documents. They've got signatures on them usually. So you can go on there, find a signature, do some, copying and pasting, and then try and pass that off as a valid will. And this gang were stealing houses off dead people by saying, these people maybe didn't have a will or they'd been estranged from their families. They'd found vulnerable people, people living on their own, and they'd forged their signatures with the signatures of witnesses, gone to the probate registry, said, this is my friend Doris, and, she's left me her house. If you're not careful, it can slip through the cracks.
Yeah.
They'll get a grant of probate.
If there's no one to challenge it.
There's no one challenging it. And they've got a house. They sell the house and they've got 400 grand.
It's been an even bigger issue than just the property. There's what's called the bona vacantia list. And that is a list that's government-based, where estates have gone unadministered. Unclaimed. And
because people don't realise that actually some people die with no friends, no family, living quite lonely lives, and then they pass, and obviously the hospital will do their bit. There might be a statutory funeral or something, but then what happens to all the? No one's then going to say, well, who's going to administer the estate? Well, that's not the hospital's.
It's not the hospital's.
The funeral directors.
It could go to the creditors, anyone who's being owed the estate, but they also don't want to take that on, that liability or responsibility. So it goes to the government, and it can be held for years. And it's actually been such a big issue recently with forged wills that the government actually had to make a decision to, it used to be published, but take it down because so many fraudsters were coming out of the woodwork from
producing wills
that weren't real.
Saying that woman that lived there left me that house.
Exactly.
Yeah. I bet there's been a lot of that.
Yeah, and it goes to unclaimed and unadministered estates. And it's one of those reasons that it's so important to, get solicitors involved, because it's not a simple process. There's a reason that, Patrick and I have full-time jobs out of this
and that you've
work.
had busy days.
Yeah.
It's keeping you busy. Right, okay, we've got one final question. My father's estate is being administrated, but there are beneficiaries who think they have not been provided for properly. One of the children was completely cut out of the will, though she had been dependent on him. Meanwhile, the named beneficiaries argue that the father had valid reasons. There is talk of mediation, maybe going to court. I'm trying to decide whether to proceed, how long it will take, what the costs are, and whether there is a chance to settle it without full-on litigation. What do we say to this person?
Anything is possible in love and war. We can settle. It's really hard to advise on any particulars without actually having spoken to the client and got the full picture out of it.
Based on that, someone was dependent on him.
Someone's dependent on him.
And they've been cut out.
Yeah.
Doesn't sound right.
Well, and that's what I was going back to what I said previously, is even if they didn't have a good circumstance and he made a letter of wishes, it's not about whether or not you had a good relationship. If they were financially dependent and they reasonably expected to receive something under the will, chances are and they were the child of the deceased, chances are they have quite a good claim
under the 75
under the 1975 Act. But again, it depends on what the court will also take into consideration is the other beneficiaries, their value of their gift, what their personal circumstances are, their relationship to the deceased, and the value of the estate as a whole.
It's always difficult with questions like this.
Yeah.
Because as lawyers, we're instantly inquisitive and we have so many more questions. And we also want to see evidence and documentation. Why do you say she was dependent?
Yeah.
Is it very well to say, well, she was dependent, she'd been cut out. Why? And then the answer might be, well, she lived there. Or he gave her an allowance, or she had a credit card that he paid off every month. Things like this then start to indicate more dependencies.
Yeah. Whenever I meet a client for the first time, they'll tell me their side of the story. And I say to them at the beginning, I'm probably going to be quite annoying, but I'm going to keep saying to you, prove it.
Yeah.
Show me the receipts. What's the evidence?
We're just trying to make your case stronger.
Exactly, because I want to go in front of a judge fully armed and say, look, the person who's been disinherited, there was perfectly good reason to do so because these text messages, so they had a massive argument and he didn't care about the welfare of the parents, and show all the good evidence to say that, the other beneficiaries have acted properly and the executors are acting properly. So whenever I meet a client, I say, prove it, because I want to put them in the best possible position to go in front of a judge if that becomes necessary.
Yeah. Great. Right. One of the things that we haven't covered, but we want to cover is trustees. Mm-hmm. What is a trustee?
Trustee holds a similar position as an executor, and they'll be used typically interchangeably in wills. Because essentially, when you're going through the administration process, the executor becomes a trustee. They are trusted to take care of the money, the funds, on behalf.
Follow the instructions.
Follow
of the
the
will.
instructions of the.
Because the will is just an instruction book.
Yes,
like
exactly.
the old-fashioned Haynes manuals for cars. Yeah, you just got to follow it to the letter.
Yeah, and so the testator is trusting that that person will follow their instructions and do what's good on behalf of the beneficiaries.
So a will is a trust.
Yeah, essentially.
But I think people don't realise that.
Yeah.
You know, when they're making a will, they are setting up a trust.
Yeah, and that's why we use the term trust fund, and people say, "Oh, I don't want to create a trust fund." No, it's a testamentary trust is what we would call it.
Yeah,
yeah,
it's an interesting point. What's haven't we talked about powers of attorney? Mm-hmm. Who wants to help us with POAs, powers of attorney?
POAs. So powers of attorney can be really useful if, as people get on into their later years, they might not have lost capacity. They might be mentally quite sound, but they might become a bit more forgetful. They're not quite as capable as they were in their younger years to deal with their affairs.
Walk into a room more often and forget why they were there,
exactly.
why they've gone into that room.
So,
I mean, we all do that, but it becomes more frequent.
Exactly. So there are a couple of different types of powers of attorney. There's one called a lasting power of attorney, which is where you can give, what you call your attorney. It could be someone you trust, your children, could be a solicitor. But you give someone that trust to make decisions for you. And that could be for your property, so dealing with your finances, your bank accounts. It could be to do with your health. So, if you want to make medical decisions, rather if you want them to make medical decisions on your behalf, should the worst happen and you're in a coma, you've had a stroke or something. These aren't nice things to think about, but they're really important that we think about them ahead of time. Because once you've had a stroke, if you go into a coma, it's too late. There's no one there fighting your corner or with the authority to make those decisions for you.
I always say that the POA, the power of attorney, is sometimes more important than the will. Because the will, you'll be dead. Yep. So why do you care?
Yeah.
But the POA is something that comes in while you're alive and is going to deal with who's going to manage your affairs to make sure you receive the best possible care.
Yeah. And it's one of those things where it is daunting to think about. But tomorrow isn't promised.
No.
My mental
today
health
isn't promised.
Today isn't promised. It's one of those things where I could, slip, fall, and hit my head very hard and go into a coma, or suffer a stroke.
There's cables and a table.
Exactly.
It's a hazardous environment.
Yeah, very.
For lawyers.
Yeah. Who would have thought? And so without those documents in place, it's not going to be your spouse who makes those decisions. Maybe you have some debt that your spouse doesn't know about. They can't sort that out. They can't access those bank accounts to pay for medical fees. It's a very scary, thing that I've had to deal with in real life, not personally but professionally. People have come to me and said, "Well, my husband had a fall. He has a business and a company. He has separate bank accounts. How do I go about that?" And you have to go to the court of protection. It's a specialized court where it deals with people who don't have capacity. And it's a very expensive and time-consuming matter to go through.
Process,
Yeah. Whereas, doing the lasting powers of attorney, it's,
relatively cheap.
Relatively
in
cheap.
comparison to the court of protection.
Exactly. And it's relatively quick.
And when people say to me, when they're doing their will, because they always come for their wills, and they say to me, should I do a power of attorney? Absolutely.
Yes.
and I give them that example. It's more important, really, because you'll be alive when you need it.
And there's a couple of myths that people, still believe in. You have to, years of, podcasts and textbooks and, lawyers just screaming into the
podcast
ether.
right now, right?
We are, but there's no such
passionate about this.
there's no such
Give him
thing.
some airtime.
There's no such thing as a common law marriage.
No.
And next of kin do not have automatic rights to make decisions
That's right.
for you. So just because you're living with someone doesn't mean if you slip and fall and get yourself into a coma, like my partner would have no say over my affairs if I don't give him that authority ahead of time. So, and the same with next of kin, just because, you're someone's, husband or, brother or parent, it doesn't mean when it comes to hospital, making decisions about the health and welfare of your family member, you might not have the right to make that decision.
I think that's one of the biggest misconceptions is that people think that your marriage certificate means that you can make decisions on behalf of your spouse if they weren't able to. It's not true.
Doesn't give you that authority.
It does not give you that authority. No one is able to make decisions on behalf of you unless it's by consent of you yourself. And
So the question is, have you done your POA? Darian, have you done your POA?
I have not.
Oh, wow. So it's funny though, isn't it? Lawyers are quick to advise.
Yeah.
But it's difficult to take your own advice.
It's do as I say, not as I do.
Yeah.
We're
we're risk adverse, but
Yeah.
when it comes to our clients.
It comes back to, it's not a nice thing to think about.
No.
As I say, it's very easy when someone comes into the office, slap on the wrist, say, why haven't you done that? But, when I go home, I have to think about my own life. It's not on the top of my priority list, but it should be.
Yeah.
I'm going to go home and do my power of attorney
Today,
today.
there won't be time. You've got 2 hours to catch up with her in the office. Well, on the note that Patrick is going to get his POAs done today, we had better wrap up. Thank you, everybody, for listening to our second episode of Is That Legal? And thank you to Darian and Patrick for joining us today. We hope that has covered many of your questions that you had around the subject of probate. We could go on, and no doubt in Series 2, this will be another episode. I'm Paul Britton from Britton & Time Solicitors, and it's been a pleasure hosting you today.